All right, Senator Bailey, since you're the floor leader, just let you know. Remember, we special ordered the bill just for an amendment that came up. Council is going to explain it. We're going to attach it, I think, maybe on the floor to the Senate bill. But then, if Delegate Bhandari has the same bill, and that's here. I spoke with the Senate sponsor. She wants us to move that bill as well. So just let's go ahead and have Council speak to the amendments, and then we'll see what the will of the committee is. So. 5:15. We're just going to do this real quick. Remember, I special ordered Senator Klossmeyer's bill yesterday.
So, representative from the Maryland Association of Non-Public Special Education Facilities reached out yesterday and indicated that with the language in the bill as it was amended by the committee, they felt that there were going to be students that the non-public programs support students with special needs that wouldn't be able to attend programs in their facilities based on the language in the bill, and they basically there's an amendment in front of you. This is Amendment 808-170/1, and I believe it addresses those concerns. It provides a third avenue for these students to attend programs for their primary or secondary education. It would allow them to attend a non-public educational program limited to those programs for essentially students with special needs if, and this mirrors provision of existing law, the registrant notifies an agent or employee of the non-public education program that the registrant is required to register under the subtitle, and the registrant has been given specific written permission by the agent or employee of the non-public educational program to attend the non-public educational program. There's also a couple of cleanup changes made with the lead-in language, and that just provides, it just changes some of the lead-in language. If you're looking at page 2 of the reprint, as it came in, it provided that registrant who is a student shall continue receiving an education in accordance with state law, and then the rest of the language. This changes it to a registrant who is a student may receive an education in accordance with state law, and then it discusses the three avenues that are laid out in the amended bill.
So I just want to try to understand. The bill as it came in and went out of this committee before kept people who are sex offenders off the public school campus. Right. Does this allow anybody back on the public school campus?
No, this would be the amendment. So technically those regional institutes for children and adolescents, those programs that were in the amendment that the committee adopted at the last voting session, technically those are run by the public school system, was the information that we got, but those are specialized programs. So this doesn't put these students back in the public school system, though.
No, I don't care about the system. It's the physical location. That's all this is about. Right. Will this put? I mean, because the bureaucracy is good at saying, oh no, you're still sitting there, but now you're not this. You're not really there because we've reclassified you, but you're still sitting there. So does this put people? The objective here was to have sex offenders not in the public school campus.
Right.
Delaney High School, Morgenthaler High School. You just couldn't be there. Does this allow them now to go back into those campuses?
And sort of to correct myself, I shouldn't have said doesn't put them back in the public school system. It doesn't put them in the public schools. They're
not back in the physical campus.
Right.
Okay. It's giving them a different option for where they can give the education, but it's not back in the public school campus.
Right. These are the non-public schools that are specifically tailored for students with special needs.
Okay. Well, but there's a lot of kids who are special needs. I'm confused on that term because I have in my county we have John Archer School. It's a school for kids with special needs. They have kids there with cerebral palsy, kids there who just all kind of physical ailments. To me that's a school with special needs. But these people would be they would be highly vulnerable to sexual abuse because they can't run away. They can't. Right. So that would be like that'd be as stupid as putting COVID patients in a nursing home if we did that. So when we say, I just want to understand what this is doing.
Right. It's allowing them to attend programs at those facilities, those non-public facilities.
Yeah, I'm not going to support that amendment.
And just to be clear, also, it's not an auto admit, right? So it says that they're eligible to attend. They still have to be admitted to these programs, and then we made sure that the same type of notification that they would have to provide for the public schools, which they're no longer allowed to attend now if we pass this,
Right.
that they have to provide that same notice that, hey, like, you know, so and so is required to register on the sex offender registry.
No, I got it, but
So-
what I hear us saying is, well, now we have these kids, we got to put them somewhere, so let's put them in with the kids who have special needs, who are even more vulnerable than the kids where they were before. And that's our out here. It's a special needs school. That's what I'm hearing you say, and I.
We're well equipped to deal with some of the complications and trauma
Yeah, but those.
with the individual. Not necessarily, yeah. I mean, it's also not an auto admit again. It's just an eligibility.
Yeah, but I'm sorry. You can roll it. I'm going to vote against.
No,
this.
I hear you. I hear
cannot
you.
see supporting something that puts these. You know, I realize these kids are have problems, but their problems are not that they're criminals. Their problems are they have birth defects and other mental defects and physical defects, which makes them highly vulnerable, more vulnerable than the general student population to be victims of sexual abuse. And if we're going to put these sex offenders in with those kids, then I'm a resounding no on this amendment. And they have to come up with something else. If that's what we're doing, it sounds like we are. And so you can roll it. I'm not going to go for that amendment.
Thank you. Just a quick question. On page 2, line 31, 32, could you explain the change in the may and the shall again?
Going back and looking at the language, that seemed to be more clarifying than anything. As I was reading it, it sort of stuck out, and it's kind of one of those things where you go back and you notice something new. This was a situation where, just reading the language that says "shall continue receiving," seemed like it wasn't clear as to whether or not it was that this was what the statute was laying out was only for existing students, or if it would continue for students in the future. I think from a policy perspective, it would probably, just the read of it, even as the language was there, make sense that it's going into the future as well, because those students are still required to get an education. So this just cleaned it up to say that, it just seemed like clearer language.
We have a full committee now, so we're going to switch back. We're going to table this conversation. But Senator Hedelman, go ahead first, and then we'll table it so we can get back to the police
Thank you,
bill.
Mr. Chairman. I just wanted to address some of the concerns because the director of MANSEF, which is the Maryland Association of Non-Public Special Education Facilities, did reach out. And I just wanted to read a section of her letter, which states that central to our mission is to serve students who can't otherwise be served at their local public school for a myriad of reasons, be it instructional, social, emotional, or behavioral. And then she says, in fact, some of our programs have established trauma-informed approaches specifically for students who have sex trafficking in their histories. Our members support the intent of the bill, which we believe is to uphold the safety of students with the utmost importance. So, I mean, this is the head of the association that represents all these schools who is pointing out that some of them have this exact expertise and feel capable of addressing the needs of the students that we are potentially sending to them through this bill. So I just want to make that clear. Thank you.
Got it. All right. Yeah, so thank you for that clarification. Okay, so now that everyone's here on the committee, we're going to switch. We're going to table that conversation. We'll switch back over to House Bill 670. So just for just a little bit of backdrop, the House has the 9 bills that we sent over. We have the 1 bill. We're going to start working on the only thing we're going to take here from the Speaker's bill is we're going to address the LEOBR process, the repeal and replace. And so that's what you have before you today. I know that we went through the entirety of the Speaker's bill on Friday, so folks have a pretty good understanding of what was in the the bill. So today, just to have council walk through the LEOBR process that we have before us and some of the additional changes that we've made. You've got an amendment before you. This is an amendment born out of conversations that I had with the chair across the street, and going to be the topic of our conversation. So with that, Jamie, if you could start us off with the overview of the process.
Sure. So the bill, as it came in from the House and as it's amended here, repeals the LEOBR and requires the establishment of a couple of different entities. This includes the county accountability boards. Just get to the right place. Sure. It was too big of a package to include the front part of the amendment, but it is a reprint that's the thick reprint that was on your desk this morning. It's 108875/1. Starting at the reprint, the language starts at page 28. And this is where the bill gets into the law enforcement discipline. So this strips out, these are the definitions, and then if you turn to the next page, what the amendment does is it strips out the independent investigative agency. You may recall that the independent investigative agency was set up in the House bill to work in tandem with the disciplinary process, but their focus was more on the investigation of police shootings and incidents that resulted in death or serious bodily injury, and then reporting those to a state's attorney. That language isn't being dealt with in this bill. But what happens is each county with the amended bill and as it came in is required to have a police accountability board. Right, that's page 30 of the reprint. And if you look at lines 6 through 14, it just lays out the responsibilities of the accountability boards. They're to hold quarterly meetings with the heads of law enforcement agencies and otherwise work with law enforcement agencies and the county government to improve matters of policing, appoint civilian members to charging committees and trial boards, receive complaints of police misconduct filed by members of the public, and on a quarterly basis review the outcomes of disciplinary matters considered by charging committees. So that's the accountability boards. And if you go to line 31, or excuse me, page 31, at the bottom of the page, this starts the next layer of this process. It requires each county to have one administrative charging committee to serve countywide law enforcement agencies and local law enforcement agencies within the county. These charging committees include the chair of the county's police accountability board, a designee of the district public defender, who's a resident of the county but not employed by OPD, and not currently representing a party as an attorney in a criminal matter pending in a court in the county. There's also a designee of the state's attorney with the same requirements, not currently representing a party in a criminal matter and not employed by the state's attorney. One civilian selected by the county's police accountability board.
One of the changes we made was just the anonymous complaints.
Right. And I do want to highlight, just turning back to page 31, there's language between lines 20 and 24 that strikes the requirement that complaints include or would not need to include identifying information of the complainant, so would remove anonymous complaints from the process. Right.
The initial bill allowed for it, we struck that out.
Right.
It still has to, so you still have the requirement that it's under penalty of perjury, but if you're gonna have that coupled with Anton's law with just, unfettered access to records and anonymous complaints, that's the balance.
I'm going to argue to change it, but I will say that part of the discussions that I was involved in around the Baltimore Consent Decree and involving the Civilian Review Board and their ability to receive anonymous complaints was the rationale for that was the actual retaliation and the fear of retaliation, and some people wanted to bring complaints forward, but were just really afraid that they would be retaliated against. And this wasn't only citizens, it was police officers too. That they were very afraid within their own agency that they might be retaliated against. So I'm just letting you know I understand why it was important. I don't think it happens very often, but I don't know that there's a harm in allowing for it. They don't have to investigate it if they don't think it's valid.
I'm looking on page 31 of the reprint, lines 3 and 4, or I'm sorry, 2 through 5. It says a complaint need not include identifying information of the complainant if the complainant wishes to remain anonymous. So doesn't that allow anonymous complaints?
Senator Castle, you actually picked up on something that during the discussion that's just there, I picked up on as well. I was going to mention that there would need to be a conforming change there to strike that language as well.
That should go.
Right.
Okay.
So the idea with it was that the ability for anonymous complaints or the authorization for anonymous complaints under this wouldn't be there. That
Would not be there.
That
Okay.
language would be stricken.
All right, so that'll be
right.
stricken. Okay.
Sure. So I guess
Page
the change
31.
that I did make is at lines 21 and 22 on page 31. That repealed the provision authorizing a complainant to not include identifying information if the complainant wished to remain anonymous. And there was one that I missed there that just wanted to point out, and Senator Castle noted that we need to make that change as well at lines 3 and 4. And the difference there is the reason why that language is repeated is because one is to the accountability board, and one is the one between, starting at line 7, applies to the law enforcement agency. So those are the complaints made to the agency.
You go to either board. Right. And that's another thing. That's another reason why you probably don't want anonymous complaints. Okay. Senator Hedelman.
It says notarized or sworn. You mean you can just sign something saying you're swearing that you're telling the truth? Is that right?
Well, it wouldn't need to be. So what the language would still say is that the complaint need not be notarized or sworn under penalty of
Or
perjury.
need not be?
Either one.
Okay. Okay, thanks.
Thank you, Mr. Chair. So two things. I have a hard time with allowing people to file complaints that where there's no, where they're not saying that what's in the complaints is true. But even more here, we've eliminated that earlier language, and there's no longer any language in this bill which would say who would investigate the complaints. The bill is totally silent on who would investigate the complaints.
If you look to the actually the chart that's on the screen.
Yeah.
So with this, it would be the local agency that's.
Setting up,
Yes.
we're building that.
Yes.
That looks like the nightmare chart when they set up Obamacare.
That's what we're setting up?
Yep.
Oh my gosh. Okay.
But I see what's on the chart, but it's not in the bill. We deleted the language, which I agree with, about this statewide independent investigatory agency.
Right, and their function was limited, even as the bill came in, was limited to looking into the criminal aspects of incidents of misconduct involving discharge of a firearm, death to an individual, or serious bodily injury.
No, I agree with that, but where in the bill currently is there any language requiring an investigation to occur? And saying who's going to do it?
You know, Senator, it's a good question. I don't know. I know that the current process is obviously that the law enforcement agencies do investigate misconduct complaints against officers. That's handled through their investigators with their internal affairs division.
So we're just going to leave that out? And
right. I specifically, I don't know. I'd have to give it a quick look, but I don't know if that language specifically requiring the agency to investigate is included there. I could give it a quick look. But
we had that in our bill, but I don't believe it's in this bill.
Right. I think the assumption is that they would do the investigation, and then it goes to the charging committee, which makes the ultimate decision on whether or not to charge administratively.
Okay.
Thank you, Mr. Chairman. Getting back to page 31, when we talk about the complaint need not be notarized or sworn to under the penalty of perjury. What is the situation when we have someone that files a anonymous complaint that is done for willfully and maliciously against an officer to get that officer or group of officers in this investigation, and then it turns out that there was nothing wrong? If they do not swear to that or sign that, what is the recourse legally?
If you give me a minute, Senator, I can look that up for you. I do have something in mind, but I just don't have it in front of me. And it also, under this circumstance, it wouldn't be an anonymous complaint. So it would be tied to an individual's name.
That's exactly right. But the whole reason that they signed the document was to sign it to say what they were saying was a truthful representation of the complaint. This just is like, well, that was a misunderstanding. That's what they said. That's the way it turned out in writing. But that's not really what I meant. Should have to sign for it. That was in our document, right? That they had to sign for it.
Specifically recall on that one, Senator.
It was in there that they had to sign.
That they
right. That they had to sign if they did that. We're talking about people's careers, their lives, their children's future. The whole scenario when we talk about these complaints. This is a situation that we should definitely require someone to at least sign. When you go in and file a statement of charges, criminal charges against any person, if you're not willing to sign, then it doesn't move forward. Right? I have no idea why we are setting up a separate double standard that does not exist anywhere else in the law.
So, Senator, I just found what I was looking for. Under 9501 of the criminal law article, it prohibits a person from making or causing to be made a statement, report, or complaint that the person knows to be false as a whole or in material part to a law enforcement officer of the state, of a county, municipal corporation, or other political subdivision of the state, cause an investigation or other action to be taken as a result of the statement, report, or complaint. Person or dollars or both. Actually, the current language in the LEOBR that prohibits false statements cross-references the section that I just read. So that's under current law, that's what they would be prosecuted under. So that section of the criminal law article would still be in effect, even if the language isn't directly there. The penalties are, it's a misdemeanor that carries a maximum of 6 months, or a fine not exceeding $500 or both.
Yeah, so this is their version of Leobar, and this is what we're sending back over, correct? Where is all of the existing portions of Leobar? I don't know where, are they all just gone?
There are provisions, Senator, dealing with, right, the political rights and whistleblower protections, as well as secondary employment.
What is missing, what is missing then from what we sent over? Financial disclosures? I didn't see it. Where's that stuff at? I didn't see it.
There's language, if you look to page 37 of the reprint, there is language that mirrors the existing LEOBR, as well as language from what the Senate passed in 627. At the bottom of the page there, provides for blood and alcohol testing, urine testing, but as far as the political rights.
I mean, there were whole sections of Leobar we kept, and I'd like to see where I'd like to see where they're at.
Right there, I'm looking for it now, but the political rights, the secondary employment, we didn't actually we'd never reinserted the.
Yes, we did.
No, from 26 to 31. I don't think we reinserted the tests in alcohol. We were going.
No, we didn't do that. But
that's here.
We probably reinserted 3 whole sections of Leobar
Yeah, we did.
back.
The only thing I think is the financial
So, Senator,
disclosures.
we did do something on the financial disclosures, but the part that I wanted to point out is page 39 of the reprint. If you start at the bottom there, it provides for, starting at line 22, the officer's right to have assistance of a representative. Below that, it's the new 3-110. It says that an officer may not be discharged, disciplined, demoted, denied promotion, transfer, or reassignment, or otherwise discriminated against if the officer, these are the whistleblower protections. On the next page, there's provision protecting lawful exercise of constitutional rights, right to bring a suit, right
Okay,
to
I see it. And then
engage in
there's
political
so
activity.
all right, so it's the whistleblower, the expungement, and then the first section. Okay, that we kept. Okay, I see it. Thank
And
you.
the actual the interrogation or interview process, whatever you want to call it, they inserted and we never got around to it.
And then my last question is on, explain to me on page 30, because we ended up nixing having each county have its own boards. What are these? These are not disciplinary boards. These are just accountability boards that they meet with and give feedback to the police. They don't actually do discipline, do they?
Aren't the disciplinary body, although they do appoint the civilians who are involved in the disciplinary process. So part of their role is to appoint civilian members to the charging committees as well as the trial boards. That's at lines 9 and 10.
They do not have subpoena power.
All right, last question. It looks like it's changed as far as when the chief shall remove. Did we have that language about probation, or about PBJs in there?
Up, Senator.
Right now it says the chief shall remove, and there lists a bunch of PBJs. Hold on. Gotta find it. I circled it. It's a PBJ, and it's domestic violence is in there. Yeah, page 37. Starting at C.
Right, so there was a provision, if you're looking at subsection G, allowing for, or actually requiring an emergency suspension pending an investigation, administrative charging committee, trial board, and criminal prosecution if the officer was criminally charged with those offenses. So a felony, misdemeanor committed in the performance of duties, misdemeanor related to domestic violence, or a misdemeanor involving dishonesty, fraud, theft, or misrepresentation.
So just to be clear, we changed that from a may, not a shall. It came in as a shall.
Right, and the language now provides that the chief may impose an emergency suspension with or without pay under those circumstances.
Yeah, so I'm talking about my question is on C. The chief shall terminate the employment of police officers convicted of or receives a probation before judgment. And look at 3 or 4. I mean, 3 is clearly, 3 strikes me as political. Why wouldn't you just do assault? What if he just assaults anybody? Why would you differentiate between the domestic violence and a straight assault? But also, it gets into PBJs. I mean, I just wish we'd be consistent on these. Either we're going to treat them like convictions or we're not. We just killed a drunk driving bill because we were not going to treat PBJs like a conviction. And then we got a bill in front of us now that, again, treats PBJs like a conviction. So we should be consistent on this. So we're going to have somebody lose their employment because of a PBJ now?
If we're looking at subsection C, that mandatory termination would apply. That's an or. So any of those things, and the felony, misdemeanor related to domestic violence, or the misdemeanor involving dishonesty, fraud, theft, or misrepresentation wouldn't have to occur in the performance of duties.
Yeah, I understand that. That's patently obvious. What I'm saying is that's bad policy. When we sent it out of the Senate, we sent it out as may terminate for this, right? Not a shall. Is that correct?
I'm sorry, Senator Radley.
When we sent it out of the Senate, this said it said the chief may, not shall, correct?
Well, so the Senate bill in 627 don't believe had a mandatory termination provision.
So we did not have a mandatory provision. So maybe someone can explain to me why this is in here and why they feel this is good policy. Does somebody want to defend the language? I mean,
So, I mean, the discussion is centered on, look, I mean, the felony, and then obviously the misdemeanor committed in the performance of duties as a police officer is that's obvious, it's a why.
yeah.
And then the domestic-related offenses, I mean, I think the discussion with the counterparts over in the House is that these are, of such a nature that if it's dishonesty domestically related, that, the chief should be able to, or should have to terminate your employment as a law enforcement officer.
They shall. So, but if I walk
Yeah.
across the street and I get in a fight with my neighbor and I punch him and take a PBJ, nothing. But if you get something happens in your household, you get accused of something, and your lawyer tells you to take a PBJ just to end it, you lose your job. So this just bothers me because I don't think we should be treating. I have no problem if they do a felony. They're convicted of a misdemeanor related to dishonesty, fraud, theft, misrepresentation. But domestic violence is put in here. To me, that's political. Because there's groups down here that want that in. I'm not condoning domestic violence. It's terrible. But what about first-degree assault? What about What about other violent crimes? Where's rape? Where's drunk driving? You go down this road, we're going to have a bill in every year. What a PBJ on drunk driving? What a PBJ on rape, sexual assault? You know, you could do the list. So why are we picking that one group out, domestic violence, and then why we shouldn't have PBJs in here at all? That's a major problem. Either we're going to treat it like eviction or not. And to show some intellectual honesty, we just defeated easily a bill on here for drunk drivers. Then we're going to say we're going to treat police officers harsher than we treat drunk drivers driving around the streets? And that's absurd. So we should strike this language on the PBJ stuff. Otherwise, we're going to have a bill on the floor that says, drunk driver, you don't get ignition interlock. Police officer, you lose your job automatically on a PBJ.
I'm still back where we started, I'm afraid.
On this that we, I mean, that would be my first, well, I'm fine with a felony. If they get convicted of a felony, I'm fine with that. But I just don't want PBJs in there. I think we should just take PBJs out. So that would be my amendment, is to take PBJs out. Because I think just as a committee, we should be consistent on this stuff. Either it's a conviction or it's not. And we'd already decided once in a vote it's not. So let's be intellectually consistent here. So that's I'm offering that up just to strike PBJs.
Shall terminate the employment of a police officer who is convicted or is convicted of a felony, a misdemeanor committed in the performance of duties, a misdemeanor related to domestic violence, or a misdemeanor involving dishonesty, fraud, theft, or misrepresentation.
I mean, sort of agree with Senator Huff. Domestic violence is terrible, and actually, I think there is data that shows it's prevalent. It has a pretty high percentage among law enforcement in particular. However, I don't think that it's sound policy to distinguish domestic violence, which could be a misdemeanor, and often is a misdemeanor, over every other offense. I mean, if an officer is drug addicted and has a drug conviction, that's no less serious. So I understand that it is kind of political to include that, but I don't agree that we should single one offense out above all others. Fraud, deceit, dishonesty, that all makes sense. We already distinguish that in law, like in other areas of the law. But I don't know. It's difficult to even have this discussion because I understand the political will is to always, knee-jerk reaction. Oh my God, we have zero tolerance for domestic violence, and we should. But it's just not the only thing in and of itself that should be considered as, we got to immediately get rid of these guys. To be quite honest with you, those types of things are, all manner of results can happen with those offenses. There can be mediation, there can be things that are worked out. I don't know, I have a problem with it, but I'm probably alone, knowing me and knowing how this committee often thinks about these things. At some point, I just think that we've got to really try to make sound policy and not act on emotion because we really despise some certain acts so much. Some of us do. And so I don't agree that we should distinguish one offense that's not a felony from all others. I just think that's wrong.
What does it mean? What is domestic violence?
Yeah, so I mean that's what I said. It could be a misdemeanor or it could be a felony. It could be a fourth degree assault, or it could be a a second-degree assault, or it could be a first-degree assault. A first-degree assault is a felony, a second-degree assault is not. Except if it's on a police officer, then it's a felony. So, I don't know. I'm not sure where you are on this, but. If it's a felony, because we're saying all other felonies.
On the domestic violence, we have to be careful of the law of unintended consequences. I mean, I've personally been involved in discussions with spouses of police officers where about physical abuse. As an attorney, I've been involved in these discussions where she did not want to take the matter, that she should have pushed it into court, but she didn't want to because her income was dependent upon his income. And if he loses his job, she and the kids were really screwed. So it would have been better if it would have come out and then he could have gotten the assistance and she could have gotten the assistance. But you're really forcing these spouses. I mean, obviously, if it's this, like they were saying, if it's a felony abuse or something, but if you be too draconian, what you end up is you have the reverse effect of driving the victims into the underworld so they can avoid the financial hardship of their main breadwinner losing their job, which would be the worst outcome, right? Where they sort of suffering in silence. So.
Thank you, Mr. Chairman. And as I'm sitting here listening to my colleagues' concerns about C 1 through 4, I took this stance when I served as sheriff in Prince George's County that domestic violence was our stick. So much so that the program we put together was recognized by the United States Congress. So I certainly understand the challenge of that. I definitely understand that the courts have even weighed in where a victim of domestic violence wasn't so easily able to not testify against the abuser. And I think singling this out, while it's very, very, very important, we have a felony, we have a misdemeanor committed in the performance of duty, which is what we sent over, and a misdemeanor involving dishonesty, fraud, but now we're singling out a misdemeanor, and we're a particular misdemeanor. I think I'd have to agree. I think it needs to be a felony, and if an officer were to commit a domestic violence, a misdemeanor and domestic violence while on duty, it's covered. But if it rises to the level of a felony, it's covered. I just think we need to be careful about, so what's going to be next on the misdemeanor list of related convictions? So, and I say that, as a person who has fought and continues to fight against, this piece, but I think we need to be consistent. And it is a heinous crime, but I don't think it needs to be the only one that's singled out of the others. So it's just my 2 cents.
All right. Understand the discussion. There's a motion. So I want to do, I'm going to go over to Senator Huff, but I want to be respectful of your caucus time. So I know you guys had a hard out at 10. Yeah. We'll resume this conversation. Do you want, I want to, yeah, you want to do this, and then I want to be respectful of your time. So, all right.
I'll just make a motion.
All right. What is the will of the body looking? All right. No, we're not rolling it. Carries. All right. What's your? Oh, I agree. Okay. All right. So that motion carries. We're striking that.
It goes back to Senator Bailey's point earlier, and I thought that what Jamie said was that were you citing to 9501 of the criminal law article as the basis for prosecuting false statements? Okay, but that's only if false statements made to a police officer. This process, you don't make your complaint to a police officer, you make it to an administrative body. So that law would not apply. So you could make your willy-nilly complaint, and there's no criminal sanctions for that. And because you're not even making it under perjury, you're just making a statement for which apparently there is no penalty. So I can just jerk around Officer Jones, who I never really liked in the first place. I can just make his life miserable, and there's no, I mean, that's my fear, in support of what Senator Bailey's saying.
That actually is a good point, Senator, because currently you make the complaints to the law enforcement agency, whereas
Which you
under
still
this,
can, but
there's
you don't
the
have to.
administrative body. No, that's correct. You're right about that.
Right. So if you're going to make a false one, don't make it to the police agency, make it to the administrative body, and then there's no consequences. Okay.
Stryker's going to stay a minute, and then we're going to rest so you guys can get your clogs.
So I just want to turn the committee's attention to page 32 before the minority party needs to leave for its caucus. I still have strong concerns about the makeup of this board. So we've kind of tied ourselves in pretzel logic. As we left it on Friday, everyone unanimously agreed that it is unethical to have the state's attorney on this board because they may end up prosecuting the person involved, and that it is unethical to have the public defender on the board because they may end up defending the person involved. And so the solution that was arrived at is that it's the state's attorney's designee who's not an employee of the state's attorney, or the public defender's designee who's not an employee. The problem is, I don't think that gets us out of the ethical conundrum. It gets us out of the Office of Professional Responsibility. Like, technically, this might be ethical, but it still has the same width of concern that the original concern did. So the state's attorney is still involved in the process. They are one step removed, but they now have a designee on the board. And the public defender is one step removed to avoid the unethical appointment, but they're still involved in the process. When both of those offices will later be involved if the officer is charged. The same thing is a concern on line 19 and 20, where we didn't even remove the county attorney and add the county attorney designee. The county attorney is still in the bill and still on the board. So that's line 19 and 20. The county attorney will end up defending the county if either the victim sues, saying the county was wrongful, because it's the county that gets sued, not the police department, or if the officer is like wrongfully fired or ends up suing his employer, his or her employer, the county is also on the opposite end of that suit. So either the officer or the victim can and may end up suing the county, and the county attorney will be the lead attorney for the county, but is on the board and involved in the process. So I think we have a somewhat.
No, so I agree with you on the last piece, but the first two, I mean, my concerns are probably assuaged with the not employed, not currently representing, not employed, not currently representing for OPD and for the state's attorney. I think that's enough of a removal for me, but I hear you on the county attorney piece. But again, let's pick up there when we get back. I want to respect the term. I want to respect the term. Yeah, they got to go. It's you're late. Your meeting.
I know,
late
but Jamie can look at this while we're gone. The process that we see, I don't see where there's a process for police department initiated administrative. This whole thing assumes that the police are only responding to public complaints, but the reality is, at least in my county, they're overwhelmingly police initiated complaints. Of the chief finds that Officer Jones was sleeping or in the car or having a beer or doing something, and it's not a public complaint. So I don't, and without providing those in the bill, the original LEOBR had a lot of due process protections for those. That was the focus. They kind of assumed very much that the complaints were police driven, and then you had a process so the officers didn't get screwed over by the chief. But now I'm not seeing where this bill allows for that non-public initiated complaints, which is actually the bulk of what we're going to be dealing with. in most jurisdictions.
I think in the reprint, Senator, there's something that that does kind of get to.
Well, you can give it to me later. I just
Sure.
wanted to put that out there because I thought it was a big issue that you'd want to be looking at. All right, so we'll take off and then we'll, all right, thank you. I appreciate you just hearing that one out.